where we ended, first things first, some housekeeping. From tonight, as you can all see, we are recording. So those of you who requested recording and who couldn't understand why I did not want to agree to be recorded, well, you got your way. The lessons are being recorded. So you can now be at rest as far as that is concerned. Right. So yesterday we were speaking about you being in a consultation, right? And then the things that you have to address with your client, right? Remember, I said you are going to find out whether your client has a case. Therefore, we looked at cause of actions and what that is in different scenarios. We covered a few scenarios. The next aspect that you must also be certain of is whether your client has locus standi. Now, locus standi is legal standing, right? You ask yourself the question, does my client have a direct and substantial interest in the proposed litigation? Now, if your client doesn't have a direct and substantial interest, then he doesn't have locus standi, because why would he come to court for somebody else, right? We all know that, but then there is there's the exception of the Constitution, Section 38, where when you bring a class action, you can do it on behalf of someone else, on behalf of a club, if it is in public interest, and what is this? There's another one. It will come up later. There's another exception, Section 38 of the Constitution. But basically, your client, to have a case, must have a direct and substantial interest in the proposed litigation. The other question that you also will have to look at is, does my client have the capacity to litigate? And now I'm taking you way back to your first year at university, when you were doing family law, and when you were doing, when people can start litigating, do they have locus standi, right? And we're going to look at that. Remember, a juristic person and a natural person have locus standi, but you must watch out for the following, right? But before we get to what you must watch out for, I just have our picture on here again of our two vehicles colliding, right? And to demonstrate locus standi for those of you who do not know, let me see. Right, so who would have locus standi? Right, if the plaintiff, now let's say the red vehicle is vehicle A and the green vehicle is vehicle B. The plaintiff, who is the owner of vehicle A, can claim damages from the defendant, who is the driver of vehicle B, right? There can be a counterclaim. The owner of vehicle B can have a claim against the driver of vehicle A. Now, why do I say this in this way? If the plaintiff is the driver, if the driver of vehicle A, of the red vehicle, is not the owner of the red vehicle, then that driver cannot claim from the driver of the green vehicle, because the driver is not the owner and does not have a direct and substantial interest. So I wanted to demonstrate that to you. You get that? So you must have a direct and substantial interest in the outcome of the litigation. You claim from the driver of the other vehicle, even though he's not the owner. Why? Because remember, in delict, who committed the delict? Who committed the act of driving negligently? It is the driver and not the owner. Right. Just if you think of it, there is one or two scenarios where you could claim from the owner. And I don't want to ask you to think about that, but I'm going to tell you when you could claim from the owner, although the owner was not a driver, is when the negligence or the wrongful act was an omission by the owner to properly maintain the vehicle. The brakes failed. The driver is not basically responsible for maintaining the vehicle, the owner is. So in that case, it is an omission. Remember, we did the elements of a delict last night, but that is just an A side, right? Okay, so you can have a counterclaim, as you all very well know about counterclaims. Right. Moving along. You must have a direct and not too far removed actual interest. The interest that you have must not be abstract or academic or hypothetical in the right, which is the subject matter of the litigation and to the outcome of the litigation. Right. Now, some of you might be thinking of amicus curiae. How do they come into the play? Well, amicus curiae, usually they apply to be admitted as an amicus curiae in litigation if they are not a party and they're not going to side with either of the two parties, the parties being the plaintiff and the defendant, but they are going to assist the court to come to a correct decision. That is amicus curiae. They also don't have a direct and substantial interest, but they are in a position to assist the court. Okay, that is also just an A side. So you must have a direct, not too far removed actual interest, not abstract, academic, or hypothetical, in the right, which is the subject matter of the litigation, and also to the outcome of the litigation. And so indirect financial interest is insufficient. Like, for example, if you are a shareholder in Standard Bank and I don't pay my bond, I've got a bond with Standard Bank, you can't go and sue me. That holding shares in a company does not entitle you to litigate on behalf of the company. That's indirect financial interest. Yes, you do have a financial interest into how they perform in that, but that is too far removed. That is just to demonstrate that point. Right. This is the section 38, where you could, if you don't have a direct and substantial interest, litigate if a right in terms of the Constitution has been infringed on behalf of another person who cannot act in their own name. That was the one I forgot. As a member or in the interest of a group or class of persons, in public interest, and an association acting in the interest of its members. Right? Those are the exceptions where you can litigate even though you don't have a direct and substantial interest in the outcome of the litigation. I don't know if you can recall the matter of Hugh Glenister. It might be before your time. Some of you might have come across it. That was the person who took the government to court when they were disbanding the Scorpions. Scorpions is that special unit who's now known as the, what are they called? The Falcon Afrikaans. The Hawks. The Hawks. Yeah. He went to court and it was in public interest because he himself didn't have a direct and substantial interest into why they're being disbanded. But he used Section 38 as a vehicle to go to court. Okay, right. This is the concerns that you must also have with regard to the capacity to litigate, right? Now, remember, generally, minors under 7 does not have the capacity to litigate. They are duly incapable. You remember that from your first year studies, right? And if litigation is instituted on behalf of a minor who's under 7 years old, the minor must always be represented by a parent or a guardian. What that means is that the parent or the guardian would be the plaintiff and not the minor, right? If the child is 7 years and older, 7 years until 18, because as we all know, 18 is the age of majority in South Africa. So 7 years and older, then the minor can either be represented by the parent or guardian, or the minor can actually be the plaintiff who is assisted by the parent or guardian. You have a choice when the child is older than 7, but below 7, always represented by the parent or guardian. And I think I have the citations. I know you do know what citation is. That is when you identify the parties in the litigation. Okay, so this is how, if the minor is under 7, the citation will more or less look like. Now, I've left out a few details, which I will advise you upon. Right. The plaintiff is Clive Engels, that is now the father, an adult male plumber who resides at 112 North Road, Cape Town, and who is cited in his representative capacity as father and natural guardian of Rachel Engels, a minor female scholar who resides with the father at the same address. So what I left out here is the date of birth. Courts always want you, when it's a minor, to put the date of birth, because sometimes while the litigation is ongoing, the minor may become a major, and then the plaintiff must be substituted, because then the minor can act on his or her own behalf. So you would put in Rachel Ingalls, a minor female, date of birth, and you would put the date of birth to demonstrate that child is still a minor. So that is how you would cite when the minor is under 7. When the minor is over 7 and you're not going to, the parent or the guardian is not going to be the plaintiff, but the minor herself in this example, then you would cite it like this. The plaintiff is Rachel Ingalls, a minor female scholar who resides at 112 North Road, Cape Town, and who is duly assisted herein by a father and natural guardian. Clive Ingalls, an adult male plumber, resides at, and the address. Okay, you will again put in the date of birth, which I omitted in that. Right. Sometimes, especially in medical negligence, or where the minor went to hospital because of injury sustained for whatever reason, the father will also have a claim, because the father would have had medical expenses. In that case, the father will then litigate on his own behalf and also in his representative capacity. And then the citation would look like this one. Okay, so the plaintiff is Clive Ingalls, an adult male plumber who resides at 112 North Road, Cape Town, and who sues here in his personal capacity, as well as in his representative capacity as father and natural guardian of Rachel Ingalls, a minor female scholar who resides with the father. Right, and then I have a note there about costs. Costs with both assistance and representative. The minor is still the litigant and is liable for the cost, unless the guardian institute action recklessly, is not liable for any costs. Now, what that means is that if a minor is liable for the costs, where must the minor get money? And that is, that is why some attorneys and some legal practitioners would opt to have the minor as the plaintiff, because the court, if it awards cost against the minor, where is the minor going to get that costs if the minor is not employed, obviously? And if the minor is unsuccessful and must pay costs. Remember, the general rule is the successful litigant is entitled to his or her costs. Right. If a minor has no guardian, or a guardian refused to act on the minor's behalf, there is a father, there is a mother, or there are conflict of interest between the child and the parent or guardian, then the court will appoint a curator who will act on behalf of that minor, the curator ad litem. You might have seen court cases where it says the name of the curator ad litem, and when it has the initials NO next to it, nomine officio, in his official capacity. That is when the court has appointed a curator who's going to then do the litigation on behalf of the minor, who's going to then give instructions, they decide on whether matters are going to be settled, etc., etc. A lot of our matters in our courts where parents and guardians are not present in the child's life, and where children live with grannies and aunties, usually, in my experience, curators are appointed for those. So in that case, the plaintiff is Rachel Ingalls, a minor scholar female, a female scholar who resides in the address, assisted by the curator then. Right, in his capacity as curator ad litem. Now, I don't know if you know about that case. It was recently in the was it now in Pretoria High Court? Yes. I know Judge Colopin was the judge, and they asked him this question during one of the interviews, and that's why it comes to mind. It was a case where there was a curator appointed because the father and the mother was not, I think the mother was deceased, the father was not present in the child's life. I speak under correction about the parents' availability. And the child had cerebral palsy. Now, we have a lot of medical negligence cases involved cerebral palsy, where there was a lack of oxygen during the birth procedure, and usually the court will sometimes find that the hospital staff were negligent, and if it's a provincial hospital, the MEC gets sued, and then he must pay. And in this case, this child had cerebral palsy, and a lot of money, I think more than 20 million, was paid out. They were successful with the claim. The money was paid out, but the child died. And when the child died, why am I telling you this now? When the child died, the father appeared. The child was living with the grandmother, and when the child died, the father suddenly came to the fore, and he said that the money that is now left in the child's estate is his because of the interstate succession. We all know interstate succession, where the parents will inherit. And in that case, the court decided no. We're developing the common law. It's common in South Africa that grandparents look after the children, and the court said the father is not entitled to inherit that money. The money goes to the grandmother. That is just an interesting case that I'm mentioning. Okay, minors may litigate without assistance when they're applying for a curator ad litem to be appointed. So then it will be in the name of the minor will be the applicant. Where the court grants permission that the minor may litigate without assistance, so that you must bring an application that you don't want to litigate with assistance, or when you apply to court for permission to marry without your guardian's consent, or where a statute permits a minor to litigate. Right, married women, we all know that, and we're still dealing, for those of you who've come late to the party, we're still dealing with locus standi, and we're looking at capacity to litigate. Married women in the past didn't have capacity to litigate, but we know that is now since 1993. That's old news. We live in a new dispensation. But if parties are married in community of property, for them to litigate, they need each other's consent, right? And there are 4 exceptions, which would be in your notes as to when you don't need your spouse's consent, when you are married in community of property. Let me just see if I can, off the top of my head, recall it. It is when the litigation involves your trade or your profession, if you are litigating against each other, if you are litigating for personal injuries, and the last one, if it is assets which does not form part of the joint estate. Those are the 4 exceptions, but otherwise you need the consent of your spouse. So if your client comes to you and they are married in community of property, remember they need the consent of their spouse to litigate if it's not one of those exceptions. Right. Curator ad litem is appointed usually if a person is declared of unsound mind. That is a specific application that you must bring if somebody maybe had a brain injury, or maybe is diagnosed with having Alzheimer's disease or dementia, cannot handle his or her own affairs, but he's got an estate. Things must be done in it. Family can't do it because he can't give power of attorney. He's not by his full senses. You have to bring an application to have a curator bonus appointed. Curator bonus will then do his business and act on his behalf in his business. Right? And we're going to do that as one of our specific applications, how you bring that application. We must also watch out for the following when you're looking at locus standi. Prodigals, if somebody is spending their money, recklessly, you can bring an application that a curator be appointed, and then whether they can litigate, you'll have to look into that. And then insolvents, remember there's a trustee that is appointed, and when you litigate, the trustee must be known. Fugitives from justice, these are people which are wanted by the South African police for some or other reason. They cannot institute proceedings, but they can defend. So if they come to you with a summons and they want to defend, you can assist, but not institute actions. The same with alien enemies. Now you might think, what is alien enemies? These are citizens of a country with which South Africa is at war. Presently, we don't have alien enemies, but if we did, remember, you must check. Diplomats, we all know that some diplomats have diplomatic immunity. You'll have to find out whether they have diplomatic immunity. There is a website for the Minister of Foreign Affairs where everybody who enjoys diplomatic immunity in South Africa, where their names are listed. And if you want to sue a diplomat, check that they don't have immunity. If they have immunity, you can try and have it waived by the consulate if they want to agree. Otherwise, you can't sue them. We all know the story of Grace Mugabe with that we couldn't charge because they said that she was on official business in the country and she was protected by the Diplomatic Immunity Act. Right, judges, you can't sue judges because of the independence of the judiciary, and to safeguard that, when you are going to sue a judge, you have to get the permission of the judge president in the division where that judge is presiding. And you have to write to the judge president and ask that judge president to give you permission to sue the judge. You must obviously include the details of why you want to sue the judge. It can be for anything. It can be for defamation. It can be the judge owes you money, whatever it is. I don't understand. Is there a question? Beverly, your microphone is on. Can you please mute your microphone? Beverly? Okay, thank you. Right, let me continue. Members of Parliament, while Parliament is in session, you have to sue them out of the Western Cape High Court because then they live here. Partnerships, firms and associations, when you're going to sue them, remember for partnerships, you have to sue each and every partner, remembering your company law. Right, so that is the next thing that you consider apart from the cause of action. Are there any questions regarding locus standi? As per our agreement yesterday, that at the end of each session, I'm going to allow you a question or two. Nothing? Okay, I'll proceed further. The next thing that
I have a question.
Oh, sorry, I didn't see your hand. Yes?
So when you cite a company, for example, on your summons, and then let's say one of the directors or the sole director is deceased, and then obviously I assume the executor of the state would then have the locus standi, right?
Okay. You're suing the company as a juristic person.
No, the company is suing one of their creditors, for example.
Okay, no, just come again. Who is suing who? The company is the juristic person.
Yes.
And the company is suing somebody, but you say the director of the company is no longer there. But the director is not an issue. Don't they have other directors?
No.
But the company still remains the company.
Yes.
So the company can still sue.
Okay. And then when you cite when you're doing, for example, I saw with your citation for the minors,
Yes.
when you said when they have the guardian as their representative, how you would describe it in the particulars of claim, right? And
Yes.
say that they're acting in their capacity as the guardian of so and so. So would you do the same in that context where the executor is acting for a company?
Of an estate. Not an executor. I don't know why is an executor appointed on behalf of a company? The company is not deceased. An executor is appointed on behalf of a deceased natural person. And if you are suing as a company, and then the director is not a party to that, but the company as a juristic person is a party to that. So the executor would not be involved there because the company is a juristic person.
Okay. Thank you so much.
Okay, no, fine. Mr. Katz, or is it Miss Katz? Yes?
I have a question with regard to curatorship. Can someone be both a legal representative and both a curator for a party? Is that possible?
What kind of curator? Because you get two kinds of curator, Ms. Katz. You get a curator ad litem, that one that would stand in for legal proceedings.
Yes, yes.
And then you get a curator bonus, the one that will actually handle the affairs. So which one are you talking about?
With regard to both. So I know obviously with a curator ad litem, it's in terms of litigation or legal proceedings, but with the
Yes.
bonus, can it also be the person's legal representative? Can they?
No, because that
they-
one must give instructions to the legal representatives,
Oh,
the,
okay.
the ad
Now I
litem.
understand.
But the bonus could very well, it could be the attorney who's appointed the curator bonus by the
Oh,
court.
okay,
But for
thank
the
you.
curator ad litem, it would be preferable that the curator ad litem is somebody independent, because that one will have to give instructions to the attorney on behalf of the client, or the, as we call them in papers, the patient.
Yes, yes.
Okay.
That's,
Yes.
thank you. That's perfect. Thanks.
Okay. So Daka, you were next.
Thank you, ma'am. When suing a driver in an accident who was under the scope of employment, can you also cite the company for liability, or are you only
Yes.
restricted?
Vicarious liability, yes. If he was in the cause and scope of his employment, if he committed the delict in the cause and scope of his employment, you can sue the company as well.
Okay, thank you.
Okay, Nasir Rabubi.
Yes, thank you very much. This is just a follow-up question on the one asked by the lady regarding a company suing a creditor. So I think her question was, that company had just a single director who is deceased. So of course the company is still in existence, but does not a company sue by appointing a representative to represent that company? So if that is the case, my question is, there should be a resolution for somebody to represent that company.
You are
And
correct.
if the director is, sorry, I'll wait.
Sorry, I said no, I said you are correct, yes.
Oh, okay. So if the director is deceased, who then gives the resolution? So my question is, does the executor then not come into the picture, and the executor of that director's estate then has authority to act on his behalf, even for that company, and to pass on a resolution to whoever needs to represent that company in a litigation?
Yeah, that is quite interesting. And I must tell you now, I am not sure of the answer, because is the director, directors got an estate that is separate from the company's estate. The executor is appointed by the Master of the High Court for the estate of the deceased. And he has a separate estate to the estate of the company.
Yeah.
Does the company, apart from the director, would it have shareholders? What kind of a company is it? And would the shareholders have to appoint somebody instead of that director? Because
so
being
let's
the director, being the executive for the deceased person does not automatically make you a director of the company. And I'm just thinking about that now as I'm speaking.
Yes, I asked the question because I'm currently doing my article. So it's one of the things I'm struggling with at the moment, because we have a matter where we need to draft, well, I need to draft the summons, but I'm having issues with citing the company because the sole director is dead and he's the sole shareholder as well. And the matter is being brought on, our client is the executor.
Okay. Look, I cannot give you a definite answer as to what should the company be dissolved. I don't know now. But
Okay.
I do know that the executor is the executor of the deceased person and of his estate. And we know that the company is a juristic person and have a separate estate. So it flows from that the executor of the deceased person is not automatically also the executor of the company. But I mean, I'm open to being persuaded by anyone who has more knowledge on the subject.
Thank you so much.
Okay. Yes, there's still hands up. Nasir, you were still speaking?
Yeah, I think the confusion is where that director is the only shareholder of the company, and there are many like that. All right, and nobody else can act on behalf of the company apart from the director himself, because he's not nominated any representative to represent that company. And I think that's where it's a very interesting question, because that's where it comes from now. If he's not around,
who's the company? But the company is a juristic person. So,
But always represented by a natural person in litigation, is it not? Is it not the case?
yeah, but he doesn't the company then in his estate goes to somebody? Didn't he leave it maybe in his will to somebody else?
Yeah,
I don't know, his shares as the only shareholder, and wouldn't that person then become the shareholder? And wouldn't, I don't know. I really don't know the answer to that. It is very interesting. Yeah.
let's leave it there. I think we can read up on that as well. Because
Yeah,
it's,
yeah.
No,
Yeah,
I
there's
think-
other
I think-
people also. Maybe they will contribute. Timakatsu, your hand was up. Afani.
Oh, yes. Hi. Thank you for the opportunity. I just wanted to ask with regards to citation, in a matter where, okay, the client was in an accident and he claimed for insurance and his insurance paid, but then the insurance went on to sue the driver. And now I just want to find out in the citation for letter, is it yeah, particulars of claim. How do you cite the defendant? I mean, is it
The person who drove the vehicle, who committed the dealing.
he was driving a company car. He was driving a company car, and now let's just say the company was SABC. So now he was driving SABC. Do you write SABC as a defendant, or do you write the driver as a defendant, or is it both of them?
You can have both of them.
You can have both
The
of
one,
them. Okay.
the one because of vicarious liability, and the other one in his personal capacity because he committed the act. Yes.
Okay. Thank you.
Okay. There were many hands. Edith, I remember your hand. You're not going to get away. What is it that you wanted to say?
Good evening.
Good evening.
Well, I wanted to say that with regard to the director one, would they not have to wait for the dissolution of the estate for him to actually redistribute everything, and thereafter can the proceedings go on? Because obviously the company itself, even though it's a juristic person, has to be represented by somebody, and that person will only be revealed through going through the will or whatever testament is left of the deceased individual.
Yeah, Edith, your answer makes sense but do you agree with me that it does not form part of the estate over which the executor has a say at that point in time?
I agree that
yeah.
that the executor himself cannot
Yes.
stand in place of the company and make decisions for the company. But what I'm arguing is that the executor has the power, though, to actually take the company or transfer the company to the person that it actually should be going to, to the heir, and that heir is the one that will be able to actually proceed with whatever the proceedings are. That's what I'm saying.
No, I agree with you, Edith. That was my line of thinking also. Okay. Yes. Okay. Yeah. Simangele, thank you very much, Edith. Simangele.
Thank you.
Okay, I just want to answer the lady who was asking about who to sue when the driver caused an accident using the company car. We use the cause and scope of
employment.
Employment, yes. We saw the company, not the driver. The driver was working for ABC company during the cause and scope of his employment. So we cannot sue the driver, we sue the company. Thank you.
Oh, are you saying that you can't have first defendant and second defendant? You either have the one only. Is that what you're saying?
Yes, because most of the times the drivers, you find out we cannot sue the driver as the driver doesn't have anything tangible that we can attach.
Yeah,
so on.
I hear you go after the one with the deepest pockets, but just for safety's sake, I would also cite the driver. I mean, what if the defense of the company is that it wasn't during his cause and scope of his employment and they could prove that? Then your claim is dismissed. If you have the driver still there, then it falls on him. So for safety, I would sue both as first and second defendant. But I mean, it's a choice that you can make. Yeah.
Yeah.
Thanks. Okay. Thank you. I'm going to move on now. The next thing that you also have to decide or discuss during your consultation, or it's a decision that you have to make. Obviously, you're not going to discuss this with your client, is jurisdiction, because you have to decide, if I'm going to institute proceedings, out of which court am I going to institute this proceedings? And jurisdiction comes to play. And we know that the doctrine, what jurisdiction is, it is the competence which a court has to hear and determine an issue between parties before it. That is what jurisdiction is. And then we have geographical jurisdiction, and we have, monetary jurisdiction. Obviously, you know that any matter can be instituted in the High Court. If you've done magistrates' courts already, you know that there are restrictions as to what monetary value claims you can institute in the magistrate and courts, the district and the regional courts. But you do know that in the High Court, it can be any amount, even those that you could institute in the magistrates' courts. Now, what the High Courts do is they're not very kind. If you use the forum of the High Court, where we could have used the magistrates' court, and in many cases they would say that because the claim is under 400,000, you could have instituted proceedings in the regional court, or under 200,000 in the district court, and therefore you are only entitled to your costs on that scale, because the cost scales are different. So it can have that effect if you use the wrong forum, but you can, any claim you can institute in the High Court. So remember, the High Courts have inherent jurisdiction. So, but it is not advisable, because you would not get your cost on that scale. Right, and then yeah, I've said that. Then I'm just going to tell you the reasons, and this is also going to take you back to your the reasons for jurisdiction. Just take note of Section 21 of the Superior Courts Act of 2013. It says persons over whom and matters in relation to which divisions have jurisdiction. Take heed of that. But the grounds, the basic grounds or the reasons for jurisdiction, this would ring a bell: ratione domicilii, ratione rei gesta, and ratione rei sitai. Right? I'm quickly going to go through this. I don't want to spend a lot of time on this. Domicilii usually affords jurisdiction to the defendant where he lives or where he's domiciled. You follow the defendant to where he is, right? Res gesta is where the cause of action arose, right? If it is a delict, it is where the accident occurred, where the actual act happened, what hospital. That High Court will have jurisdiction. If it's a contract, it can be either one of those reasons, where the contract was entered into, where it had to be performed, where it was breached. All of those jurisdictions will have jurisdiction. All of those divisions would have jurisdiction, right? And then ratione rei sitai, if it relates to property, either immovable property, immovable, obviously where the property is situated, movable, it can be any of the reasons, depending on where the cause of action arose, and where the immovable property is and where the defendant is domiciled. Okay, so you now decide in your consultation, out of which court are you going to, out of which High Court do you have to issue, right? Claim sounding in money is another thing that you have to look at, especially if the defendant is a peregrinus. Now, a peregrinus is a person who is not South African, but you can also be peregrinus of a specific division. If you live in one division of the High Court, you're a peregrinus of another division, right? So if a claim is sounding in money, now in the past, you could arrest a person to confirm jurisdiction, but that has been declared unconstitutional, so we no longer arrest a person. What you can do now is you can attach property of the peregrinus to confirm jurisdiction, but there's also the fact that the peregrinus can consent to the jurisdiction of the court. And then there's some debate as to you consent before there's an attachment, then the consent will do away with the attachment, even though it was already instituted, as long as the court did not order that property be attached. But after the court has ordered that property be attached, you can't consent. They will attach the property in order to confirm jurisdiction. Yeah. And then divorces, you know that the person, one of the parties must have been residing a year before the institution of the divorce in the area, in the division. Right. That's about jurisdiction. Are there any questions on jurisdiction? I think that is pretty straightforward, but I will take a question or two on that. Questions on jurisdiction? Nothing. Right, let's move on. Now you have to decide which proceedings are you going to use. Now we have the action procedure, which starts with the issuing of a summons, and unless the matter is settled or withdrawn, it ends with a trial. And we have the application procedure, which starts with the issuing of a notice of motion. Attached to it is affidavits, and applications are decided on the papers, right? On the papers means you are not going to call witnesses. At a trial, you are going to call witnesses. Those are the two different proceedings. Now you have to decide. You've now done that. You've written your letter of demand. Nothing happened. And now you have to issue. You know which court. You know your client have locus standi. You know the cause of action. Now you must decide which court you have to issue out of. There are two proceedings. We know the action and the application. And the differences of the two is most obvious difference is what the parties are called. The parties in an action are called the plaintiff and a defendant. In an application, they are called an applicant and a respondent. Right. Please take heed of this. In your exam, when you're going to write, and I've seen this many times, when people write, they start with it's a particulars of claim, and then halfway through the particulars of claim, they're talking about the applicant and the respondent, and they get confused with the parties. Name the parties by the correct names, because you will lose marks if you call them incorrectly. Okay. An action deals with substantial factual disputes, whereas an application, the dispute is not so substantial. So it can still be decided on the papers, right? And we'll deal with that when we do applications, right? Actions commences with the issue of a summons. And after the summons, depending on which summons you are going to use, there you get two kinds of summonses. You get a combined summons and you get a simple summons. If a combined summons is used, it will be accompanied by a separate document called the particulars of claim. Right. After the summons has been issued, the defendant will usually file a notice of intention to defend and then a plea. And if he has a counterclaim, together with the plea, will file a counterclaim, right? And then after the plea, the plaintiff get another chance to file a replication, right? And then there are even further exchanges of other pleadings, which I will deal with later. In an application, you have the notice of motion. Now, in the notice of motion, you will say what the relief is that you are asking for, and you will attach to the notice of motion an affidavit where you will set out your case. The affidavit is deposed to a deponent who has personal knowledge of the facts. It can be the applicant, or it can be somebody that has personal knowledge of the facts. And it will be set out there, and to the affidavit, there will be documentary evidence attached. After the notice of motion and the affidavit is then served on the respondent, he can then file a notice of intention to oppose if he wants to oppose, and then file an answering affidavit where he answers the allegation, and then the applicant files an replying affidavit. Now, at the end of the replying affidavit, everything is now done in the application. Now the matter can be set down, heads of arguments are filed, and practitioners then go to court and they argue the matter. So all the facts must be set out in the papers, right? With an action that we said end in a trial, after the close of pleadings, we come to another step where we do the practical arrangements of the trial, where we have discovery, where we have pre-trial conferences, case management conferences, where we have all of those practical arrangements, and only after that, the matter, if it's ripe for trial, is set down, and then you will have the actual trial where you will call your witnesses and they will under oath then give evidence in court. So you will see that the action procedure takes longer, it's more work, and it is more expensive. Also on the court rolls, since initiating an action procedure up until you get your day in court, it can be anything from a year to 2 years that you wait for your day in court, depending on which division and how quick they are with their case flow. But it's in all cases that I've seen, it's not less than a year that you will get a court date to have your trial actually heard in court. Right. With an application, it's quicker. If it's an opposed application, then it can be in the next term that you can get a date. So applications are quicker, it's cheaper, but you must be certain that you use the correct form of proceedings when you choose your form of proceedings. Right. So when you decide to use the action with the application, remember, you are now sitting in your office and you now the legal practitioner, and you must now decide which one am I going to use. Right. You ask yourself these 3 questions. The first question is the action procedure mandatory? Now, in some instances, you have to use the action procedure. You don't have a choice, right? So if the answer is yes, then you use the summons. Like, for example, a divorce is not a divorce. You never get an application for divorce. It's always an action. Claims for damages, it's always the action procedure. You would not use an application for claims for damages. Right. So divorce, claims for damages, those are 2 examples where it is mandatory to use the action procedure. Right. If the answer is no, it is not mandatory, then you ask yourself the second question. And the second question is the application procedure mandatory? And in certain instances, you have to use the application procedure only. For example, an application for sequestration, an application for the appointment of a curator. Application, that is an application for the eviction of illegal occupants. What else? Application for declaring somebody dead. Those are all applications. So you would use the application procedure if it is mandatory. If the answer is no, and then you ask yourself the third question, and here is where you have to make the call as a legal practitioner. The third question is, can I foresee a real dispute of fact? Now, if you can foresee a real dispute of fact, then you must use the action procedure, right? Because a dispute of fact that cannot be decided on the papers, it can only be decided by calling witnesses where they are cross-examined and where the veracity of what they are saying are being tested. Then you must use the action procedure. If the answer is no, there is not a real dispute of fact, then you use the application. Now, you might have a problem with real dispute of fact, because dispute of fact is the reason why we're going to court. I mean, really, we are fighting. So even if it's the application, we are still fighting. We are not agreeing. That is why we want the court now to decide who's right and who's wrong. So there's always going to be a dispute of fact. We can't get away from that. But now they say, can I foresee a real dispute of fact? And with real, they mean a dispute of fact that is not able to be resolved on the papers. I don't know, taking you back to your studies, read the case of Room Hire versus Jeppe Street Mansions. I don't know the citation. I think it is in your notes. That is where the court decided what is a real dispute of fact and when it is not a real dispute of fact, right? And you only can really determine this after the fact, after you know what the defendant has said in writing. at the stage where you are in your consultation, where I have you now, and you have to decide whether there's a real dispute of fact, you only have to rely on what your client tells you. Your client will say to you, and then the defendant did X, Y, and Z, and I went there, and this is what he said. And from that information, you must now determine whether there's a real dispute of fact. And if you maybe choose wrong, you can have your case dismissed. But there are other ways that the court also deals with a dispute of fact. If you used the application procedure, which would be the wrong procedure, the court has ways of dealing with that. And I will come to that when I do applications. But yeah, so we are now going to first do action procedures. Okay, and we're going to start with issuings of the summons. So there are 4 stages in the action procedure. The pleading stage, where we define the issues, we actually see what it is that we are fighting about in the pleadings. In the pre-trial stage, that is the stage where we're preparing for the trial and where we do the practical arrangements. And then we come to the trial, where we actually place the evidence before court. And then lastly, the court will give a judgment. And that is the decision of the court, subject to appeal and review. Okay, remember I told you that the court can only consider evidence, and if it gives a judgment, it must motivate the judgment and give reasons as to why it makes a certain finding. Right, so the argument stage, sorry, do I have any questions? I don't want to just go on without giving you an opportunity. Do I have any questions at this stage? You must tell me if I'm talking too fast. I have that habit of speaking very fast. Nothing? I'm going to go on. Right, so the argument stage is usually, remember, we are busy with actions, so the parties are called plaintiff and defendant. So the argument stage is between the plaintiff and the defendant. Now, the plaintiff in the particulars of claim will point by point set out what it is that he is saying to the court and why he's saying that the defendant is doing something wrong and why the balance, the scale, everything must be put in there and things must be brought into equilibrium. Right. And the defendant will then point by point set out his defense to the claim in the document that we call the plea. So we have the particulars of claim and the plea. And those are the 2 most important pleadings because they will state the facts. They will tell us what is it that the plaintiff say and what is it that the defendant say. What does the defendant agree and what does the defendant dispute? Right. Coming to that. Now, the action procedure, you have 3 kinds of summonses, right? We have the provisional sentence summons, we have a simple summons, and we have a combined summons. Now, the provisional sentence summons procedure is dealt with in the High Court in Rule 8. I'm going to come to that at a later stage. You can only use the provisional sentence summons if the claim that you are instituting is based on a liquid document. And the document that we are saying is liquid must comply with the definition of what a liquid document is, right? The provisional sentence summons includes the particulars of claim and the liquid document is usually attached. In practice, we usually attach a copy of the liquid document. We keep the original and we hand it up in court because you can't attach that. What if the file go missing? Those of you who have experience, you know that these things happen. Files go missing or contents of files go missing. So you keep the original because if you do not have the original liquid document, you cannot succeed with using the provisional sentence summons procedure, right? I will deal with that later. Now, for now, with the action procedure, I'm going to concentrate on the summonses, the simple summons and the combined summonses, right? More the combined summons, but we are going to do the simple summons as well. Now, a simple summons is called a simple summons because it's one document, it's a notice. And in that notice, it is included what the claim is about, a summary of what the claim is about. That is a simple summons. Now, you can only use a simple summons in certain instances where the claim is for a debt or a liquidated demand, right? And I will give you the other situations later on that you can also use the simple summons for. The combined summons you can use in each and every matter where you are going to use the summons procedure, where it's an action. You can use it where it's a claim for based on a liquid document, for a debt or a liquidated demand, for ejection, for a transfer of movables, and for cancellation of a contract. Those are the other instances where you could use a simple summons, but you can use a combined summons in each and every instance. Now you can see the word, it says combined. That means it's got a summons, which is really a notice to the sheriff to serve the summons, right? It's got the summons, and then attached to the summons, it's got a separate document that is called the particulars of claim. And in the particulars of claim, point by point, everything is set out. Okay. Those are the three kinds of summonses that you get. Right. A simple summons is issued when the claim is for a payment of a debt, for delivery of specified movables, for transfer of property, fixed property, for eviction, and for cancellation of a contract. So claim for the payment of a debt, claim for delivery of specified movables, claims for transfer of fixed property, claims for eviction, claims for the cancellation of a contract. Now, a simple summons, like I said, it's just the summons, and it has a summary of the cause of action. In practice, you will sometimes see people are not detailed when they use the simple summons. It may just say for goods sold and delivered at the amount of 300,000 Rand plus interest or whatever. It will say something like that. It won't give you the finer details as to when the contract was entered into by who and all of that, as you would find had a particulars of claim been used. Okay, but you can only use it in those instances. It is never to be used if the claim is for damages. Right? If it is for damages, that has to be determined by court. Remember, you must then set out what the damages are that you have suffered, and then you would have used the combined summons. Like I said, it may be used in all cases, and next to the summons is a document setting out the material facts. The particulars of claim must be signed by both an attorney and an advocate. The simple summons doesn't have to be signed by an advocate. It can be signed by an attorney alone. And an attorney, when he signs a simple summons, he does not alone, when he signs it, because he can only sign it, he does not have to certify that he has right of appearance in the High Court. In the combined summons, in the particulars of claim, if an attorney signs it alone without counsel or an advocate also signing it, then the attorney must, underneath the signature, certify that he has right of appearance in the High Court. Now, the right of appearance in the High Court, I told you, it's in terms of the Right of Appearance in the High Court Act of 1995. Attorneys with 3 years experience apply to the registrar of the court, and then they get certified with right of appearance in the High Court. That is how it's done. An attorney can sign alone when he or she has right of appearance in the High Court. Otherwise, an attorney and an advocate must sign. Right. Now, processes can be issued on court days. Now, what issuing means is the registrar of the court issues it. That means it gives it a case number and it opens a court file for it. So you take it to court. In the past, long ago, you had to put on revenue stamps, but that has been done away with now. You only take it to the office of the registrar. They issue it, meaning they stamp it with a court date. They give it a case number, open a court file with a case number. You then take the originals away and you make however many copies you need to make, depending on how many defendants there are. And then it's taken to the sheriff by you, and the sheriff will go and serve it on the defendant. Before it is served, it must be issued. Right? These are the times. The times may be different for different divisions. I know that in Gauteng and I know in Cape Town also now, it's only until 1 that you can issue. They don't issue anymore in late afternoon. But you must check the practice directives of the specific division in which you are practicing for when you can go and have it issued. Right. And then you take it to the sheriff, and the sheriff will now have to serve it, right? And service is dealt with in terms of Rule 4 in the uniform rules. Right. Service may not be affected on public holidays and Sundays unless it is an interdict or a warrant for arrest or attachment to find or confirm jurisdiction. And these are the hours that service is. You can get out of that, but then you have to pay the sheriff more out of those hours. Improper service gives ground for noting an exception. Improper service would mean when the sheriff didn't go and serve it. And in terms of the rules, it had to be served by the sheriff. And we know that the first process must always be served by the sheriff. Remember the audi alteram partem principle. First processes must always be served by the sheriff. It is a criminal offense to obstruct the sheriff in execution of his duties. You can get a 500 Rand fine or 6 months imprisonment if you withhold the sheriff from going to serve processes on a defendant or on a respondent. Right. Okay, so just have a list here of all the processes that is directed to the sheriff. That means that the sheriff serves, and it is not an exhaustive list, but just to give you an idea of the sheriff's duties. A summons, you see in brackets the form, that is forms forms to the uniform rules. So it's part of the uniform rules. There is that form, right? A writ of arrest, form 4, a simple summons, which would be form 9, a combined summons, form 10, a subpoena, a writ of execution, a writ of attachment of immovable property, a writ of commitment for contempt of court, a writ of attachment to find jurisdiction, notice of motion, applications for leave to appeal by petition. Yeah, so those are the documents that the sheriff can serve. Right. Personal service should be used whenever possible. So that is that gets first prize. If the sheriff has to go serve on the defendant or on the respondent, preferably personal service. We only want to use other methods when the defendant is elusive or untraceable. Right. When the sheriff serves the summons or the process, he hands the relevant document to the defendant personally. And if the defendant is a child under some legal disability, then it must be delivered to the guardian, or if the curator has been appointed, to the curator. The court practice is that personal service is required in divorce cases and when an attorney seeks to withdraw as the attorney of record. Now, there must be personal service in all matters where the status of the defendant or the respondent is going to be affected by the relief that is being requested from the court. So if it is a divorce, there must be personal service on the defendant. Right? In the case of sequestration of an estate of a person, there must be personal service on the respondent, because that is an application. Okay, Jacob, why are you requesting control? Do you want to ask a question? Jacob?
Not really. It was just a trick by mistake. Thank you.
Oh, okay. Right. Okay, the other method of service, leaving a copy at the place of the residence or of the business of the defendant or respondent. If the respondent is not there, you leave it with a person who is there, apparently in charge of that premises and not younger than 16 years old. Service at the domicilium citandi et executandi. Right, you've heard this before. we spoke about this when we did the Section 129 notice in terms of the National Credit Act. Right. Now, to explain what this means is domicilium is an address which has been chosen by a person, often in a contract, for the service of documents is sitandi, and execution of judgments, et executandi. So, domicilium sitandi et executandi. Right. Once it is chosen, it permits servants, even if the person has left the premises, since the aim of the election of such an address is to relieve parties of the duties to search for each other in order to effect service. Now, I know last night I had a question on this, where I was asked the case of the landlord, where that was given as a domicilium. And I said, if the landlord knows that the person is not there, the court won't accept that as service. So here is that. Generally, courts are reluctant to allow the use of domicilium addresses when the plaintiff is aware that the defendant won't receive notice of legal proceedings served at that address. Remember, I answered that last night when that question was posed. So if you were aware that the person won't receive it, then the court will say, no, but I can't accept that there is proper service. Please reserve. Right. The Supreme Court of Appeal has ruled that the court has a discretion whether to accept service, and depending on the circumstances. And here it is incumbent on you as a legal practitioner to convince the court that you've done everything that you can and that this was the only way. So it depends on the specific circumstances because the court has a discretion. Right. Service on a company or a closed corporation. You serve at the company's registered office or at its principal place of business within the court's jurisdiction to a responsible employee, or you can even affix it to the document to the main door. Principal place of business means, just telling you what that is. I am sure you all know what is the principal place of business. A company or a CC is said to reside in its principal place of business. Right. Partnership must be served on each and every partner. As you know, process may be left at the place of business of the partnership with a person who's apparently in charge of the premises and apparently over 16. If there's no place of business, it may be served on a partner, proprietor of firm, or chairman, secretary of the voluntary association. Local authority, the town clerk, the city manager, or the mayor. Processes must be delivered, the secretary, a member of the board, if it is a statutory body. Service on 2 or more persons being sued in their joint representative capacities. Each person must be served individually. You can't serve it on the one and then assume that the other has also been served. Right. Against the state, it must be served on the office of the state attorney in the area of jurisdiction of the court of which the process was issued. So if it is the provincial government or the national government, depending where, that state attorney must be served. Prisoners, you serve a copy on the person in charge of the prison, the head of the prison, and then the head of the prison must make arrangements that the prisoner can come so that the sheriff can hand it to the specific prisoner personally. Right? If you're going to sue a prisoner, it happens sometimes that people want to divorce a spouse who has been imprisoned, and then that comes into play. Right, now if, remember I said personal service must be effected in the case where a status of a person is going to change as a result of the litigation. If you cannot find the person or don't know where the person is, then you must bring an application for substituted service. Now this, as you can hear, is an application, which means it is a notice of motion together with an affidavit, right? So you bring this application to court and you will then tell the court, I don't know where this defendant is. For example, your client says to you, my husband left 10 years ago and I don't know where he is. He just said he's leaving. And I can't find him and I want to divorce because I want to remarry or whatever. You must bring an application for substituted service. But you must, when you bring this application, you must show the court what you have done in order to find the defendant, right? So the applicant must show that the court will have jurisdiction in the main action and that he or she has a prima facie case and the whereabouts of the defendant are unknown. The applicant must state what steps he or she has taken to ascertain the defendant's whereabouts and that these have proved unsuccessful. So what have you done? You've appointed a tracing agent. You've spoken to the place, to the last employer, to friends, whatever. All of that you include in your affidavit. You must also show that there is some reasonable likelihood that the form of service suggested will come to the knowledge of the defendant. Now, this is where you as a legal practitioner can be as creative as you want to be. If you can demonstrate to the court that whatever way you are suggesting will reach the defendant or the respondent, and you persuade the court, then the court will order that. So you can say to the court, this person is active on social media, but the person, he doesn't want to give me the address. And then you can have printouts. This is the last person. It is him. Here's a picture. He's interacting. This was taken on New Year's Day. This was whatever. You can be as creative as you want to be and demonstrate to the court and make a suggestion. And if the court is persuaded, the court will order that you serve on that platform. Okay. In terms of Rule 4A, any subsequent document can be served electronically. Now, subsequent documents, that means the first process always by the sheriff for the audio alteram partem principle, but any subsequent document can be served electronically. That means by fax or email. And we know that we use mostly email as provided for by the rules. Right. The sheriff do a return of service, a document called a return of service. That is prima facie evidence of the matters therein stated. The sheriff or the deputy sheriff must sign the return of service and it must state what documents had been served. And he mustn't be vague because vagueness is regarded as a bad return and the court will order that you reserve and that the sheriff must go again and reserve it. Are there any questions? None. Okay, we're moving on.
Yes.
Oh, there's the question. Yes.
Yes.
Terence.
Yes, Advocate. Thank you. Yes, I wanted to check. Are we still going to receive the slides, or have they been sent already?
I have not been sent yet, but you are going to receive it. And as you can see, we are being recorded.
Okay. Thank you, Advocate.
Yes. Any other questions? Okay, we're moving on. Right, so when you're drafting particulars of claim or whatever document, court documents, when you're drafting now, and we're doing action procedure, so we're specifically now looking at drafting the action procedure. We start by the heading. Now, of particular importance for drafting, look at Rule 18 of the Uniform Rules, right? It tells you exactly what must be in the documents that you must draft, Rule 18, right? So you would have the heading in the High Court of South Africa, and I've used Cape Town, Western Cape Division, Cape Town. If we've done the different courts that you have, it is on page 22 of your manual. Depending on the jurisdiction that you've chosen, that is what the heading is going to be. So if it's Eastern Cape Division, Grahamstown, or Eastern Cape Division, Tata, or KwaZulu-Natal Division, Pietermaritzburg, you will put it at the top, and that will indicate that you know out of which court you're issuing it and which court has jurisdiction to hear the matter. Okay. Then case number, you usually would leave a blank space for a case number because it's your first process, because remember, when you have it issued with the registrar, they will write in the case number. And it's usually a number stroke backslash with the year. In the matter between, state that, and then you will have, I have Peter Adams and John Smith. So the plaintiff and the defendant, and then it will have two lines, tram lines, and in between those two tram lines, it will state what document it is. If it is a notice, if it's particulars of claim, notice of intention to defend, whatever the heading is. Okay, so that is how you would draft the heading. Just take note in the exams, they would usually indicate whether they want you to draft the headings. Sometimes they would say omit the headings and the endings. And sometimes they wouldn't say that, and then you would be required to draft the headings. Right? Right, then you start by drafting by citing the parties. Now you've seen a few citations when we did the capacity to act, the minors. You would use the citations of the parties. Now, Rule 17 of the Uniform Rules deals with citations, right? Now, Rule 17 says for the plaintiff, you must state the full names, the gender, the occupation, and the address. Right? So, if it was now me, it would be the plaintiff is Laureen Abrams, a female advocate, and then and then my address. That is how it would be. Right. So you would have the full names. With the defendant, because you are not drafting the particulars of claim, your client might not know the full names of the defendant. So you will state the names by which he is known. It can be the defendant is Mr. Brown, a male whose full and further particulars are unknown. Usually you would put that because you're not required. If he doesn't know the full particulars, then you say you don't know the full particulars. But you can't say the plaintiff is Laureen Abrams, whose full and further particulars are unknown, because you're drafting it and I'm there. Okay, that just makes logical sense. A lot of these rules and stuff, it's just logical sense. Just think logical, and then you will get to the right way. Right, so you would have cases where you have more than one plaintiff or more than one defendant. We had an example here about the vicarious liability where you had two defendants. Sometimes you have two plaintiffs, right? Now, Rule 10 deals with when you have more than one party, right? Now, Rule 10 says parties who have a direct and substantial interest in any order the court might make in proceedings should be joined. Okay, so if you are instituting litigation against one party, but the relief that you are requesting is also going to affect the rights of another party, excuse me, then you have to join that party.
Advocate, your line is breaking.
Am I breaking? Can you hear me? Can you hear me?
Yes.
Yes.
Yes, we hear you fine.
Oh, sorry. Yeah. So, say for example, you are instituting proceedings for a house that has been sold to an incorrect person, registered in an incorrect person's name because it wasn't sold by the correct person. You're challenging that in court. But now the incorrect person's rights is also going to be affected. You're suing the seller, but the incorrect person who's now also have rights, have accrued rights, and his rights as an owner is also going to be affected by the order that you are seeking. He should be joined because of the audi alteram partem principle. Remember, the court can't take away somebody's rights without having afforded that person an opportunity to come to court and to say why it should not be affected. So whenever parties have a direct and substantial interest in any order the court might make, then they should be joined as a party. They should be afforded an opportunity to protect their rights before the court makes an order that affects it. So that is a compulsory joinder. Then you also, in terms of Rule 10, can do a joinder of convenience. Now, this is a joinder that is not compulsory. It is only when it is convenient, because the issues in dispute depend on the determination of the same questions of law or fact. And we can save costs if we all go to court because we want the same thing to be decided. Yeah. Just remember, if a party should have been joined but is not joined, then the defendant can raise a special plea of non-joinder. And then that will then delay the proceedings because now the plaintiff must bring an application to join a party that he didn't join. And until that party is joined, can the proceedings then start and go on again. Right. A plaintiff may also have several causes of action in the same action. Like you can have claim 1, claim 2, claim 3. For example, I showed you yesterday the divorce where you have, you ask for the divorce, that's one cause of action. The maintenance is another one. The propriety rights of the property, how that's going to be shared, that is another claim. So it's different causes of action, but it is in the same summons because it's between the same parties. So you can join several causes of action in the same action as well. When there are more than one plaintiffs, they are called co-plaintiffs. And when there are more than one defendant, co-defendants. Right? And this is what your headings would look like. So first plaintiff, second plaintiff. Some of you might have seen, especially in those cases where they have evictions against a lot of people who's maybe inhabiting a piece of land. You get pages and pages and pages of applicants or of respondents, where it's 100, 200, then each one are mentioned. So it can be however many rights are going to be affected by the relief that you are seeking, they must all be joined because they must all be afforded that opportunity. Where there's more than one defendant, co-defendants, like that. Right. Now, your client comes to you, you now received the particulars of claim and says to you, sorry, not the particulars of claim, he received a summons and he comes to you and he says, I have received the summons and I want you to help me. You then, the first thing that you do is you file a notice of intention to defend. So you would have the heading, and in the tramlines, you would have notice of intention to defend, and then you would just inform the plaintiff that you are going to defend, and in your notice of intention to defend, you must give an address within 15 kilometers radius from the court steps, where you will receive further processes and documents that is going to be served. This is not a pleading. You're not going to state what your defense is. You're just merely informing your opponent, informing the plaintiff that the defendant intends to defend. Right? Is there a question? Somebody's microphone is not muted. Yes, there is a question. Zamo, you may ask.
Yes, ma'am. I wanted to ask regarding the listing of the defendants, for example. To say, is there a rule that is regulating who must be the first respondent, second? Because I'll see a list, but I don't know how do you, if there's a rule to prioritize whether who comes first and the like.
Oh, who comes first? Look, that is your choice. It can be anyone. Usually, the main person amongst that, your client will tell you this is the main guy. You would usually put that person first, but it can be any. There's no rule to say this one must be first with that degree of interest or whatever. You would have them all there. Yeah, you can choose. They are all equal. It's just that they are. To differentiate that they are all these defendants, we put first, second, third, and fourth. But the main one would be the one that's doing the thing wrong, and whoever else you can decide. There's no real rule about that. Did I answer you, Zamo?
Yes, you did. Thank you.
Yes. Gideon?
I have a question. I'm sorry, I don't know where my raised hand thing has disappeared. May I ask?
Yes.
Or should I?
You may.
All right. Okay, so in terms of a class action, I mean, you can have like 200 plaintiffs there.
Yes.
Does each one need to be cited?
In a class action, I think everybody is cited.
Oh, okay.
I'm not 100% sure, but yes, usually you would put however many there are, you must put their names on there. Unless then it's going to be in the body, but if somebody's going to be part of the class action, their name should be mentioned. Yes.
All right, and where does one mention an amicus curiae, or that comes nowhere in the summons at all, I take it?
No. The amicus curiae would usually ask to be admitted as an amicus curiae, and that would be after the defendant. His name will be, but it will specifically say as an amicus curiae, because he is not a party to the proceedings. He is just there in his position, assisting the court to come to a fair decision. That is what an amicus curiae is.
Right. Lastly, in terms of joinder, if a plaintiff wishes to include a joinder, whether by convenience or whether it's compulsory joinder required, so are joinders actually shown either under the plaintiffs or under the defendant? So they have to be shown there. There's no separate section for including those that are joined in the action. That's my question.
I don't. You're talking about a specific section that Rule 10 deals with joinders. So usually, if a party has a direct and substantial interest in the matter, as a plaintiff or as a defendant, they should be joined. They should be.
All right.
joined.
So I wasn't referring to a section of the Act. I was actually referring to in the document that you are drafting. They are either shown under defendant if they are joined with the defendant, or they are shown under the plaintiff if they are joined with the plaintiff. Is that correct?
Yes, that is correct.
Okay, that's it. Thank you so much.
Okay. Yes, you can ask your question. Mr. Xamdaka, you are still on? Not? Okay. I will proceed.
Can I ask my mic
Yes?
was off?
Oh, okay.
With regards to the 15-kilometer radius,
yes.
What happens when, as the defendant, I'm outside of the court radius? Isn't the plaintiff supposed to follow me? So what's going to happen now if I'm being sued in Cape Town and yet I'm in Gauteng?
You get a correspondent attorney that has an office within 15 kilometers radius of the court. So you get an attorney, and you would have his address CO, and it must be served on him, and you and the correspondent attorney have an agreement that whenever documents are served, they will send it to you.
Then what happens to this principle that the plaintiff follows the defendant?
You still follow the defendant where he is, but the principle of the defendant being followed where he is, then you will issue it out of the court where the defendant resides, if that is the jurisdictional principle that you're going to use. And then, so if the defendant is in Cape Town, you will issue out of Cape Town, and then it is 15 kilometers from Cape Town court. So I'm not quite with what your question is.
But
the one doesn't cancel. It doesn't cancel you. Yes.
I'm in Gauteng. You are in Cape Town. You are suing me. Which court are we going to use? Are we going to use Cape Town, or are we going to use Gauteng?
You are the defendant.
Yes.
Where did the cause of action arose?
Okay.
It depends. It depends on those reasons. If it's based on delict, it is where the cause of action arose, in that area. If it is based on contract, it's just either of those where the contract was entered into, where it was breached, where it was performed partly. All of those courts have jurisdiction.
Thank you, Madam.
It depends on on what the cause of action is, and then you see what reason for jurisdiction you are using. And then you follow the defendant. If it's domicilium, that reason, then you follow the defendant. And then you must get a correspondent as a plaintiff near to where the defendant is, who's going to, where you will receive documents. So you will in the summons also state that you are in Cape Town, but you use that correspondent who is within 15-kilometer radius. It goes both ways.
Thank you.
Okay. Right. Any other questions? It is now 7 o'clock. So if you have more questions, you can type it like we agreed yesterday, and then I'll see what I can answer. We said last night that we're going to take a break because people said it's a marathon and they need to take a break to eat or do things. So we'll come back at 7:15. Okay. I'll put myself on mute, but you can write questions.
Perfect. Thank you.
Nasir, can you hear me?
Yeah, I can hear you. So maybe we should just chat offline if you need.
I think we can use this platform because it's a break. This question that you raised about joinder, are you trying to establish when the claim is made, when she's showing you how to write the introduction where plaintiff and defendant. Now, when you obviously have a joinder that's joining the proceeding.
Sorry, colleagues, there's still recording that is taking place.
Okay, thank you.
Yeah.
Thank you.
Yes.
Okay. So Rajan, let's take it offline.
No, it's okay.
I'll catch you.
Okay, sure.
All right. Thanks.
Recording it.
I think somebody's mic is still on.
Right, I'm back. Let me go on. So the notice of intention to defend is then sent by the defendant. Like I said, it is not a pleading. It merely indicates that the defendant has a desire or an intention to defend. Now, when must the notice of intention to defend be sent? It depends on where the defendant resides. If the defendant resides within the jurisdiction of the court out of which the summons was issued, then it is 10 days. If it's outside of the jurisdiction where the summons was issued, for example, the cause of action arose in KwaZulu-Natal, the defendant resides in Gauteng, the summons is issued out of KwaZulu-Natal, it is served on the defendant in Gauteng, then it is not 10 days as in terms of the rules, but then it's in terms of the Act, of the Superior Courts Act. And then it is, if it is more than 150 kilometers, it is a month. And if it is less than 150 kilometers outside of the jurisdiction of the court where the defendant resides, then it's 2 weeks. Right. But let's, for purposes of this exercise, then assume it is within the same jurisdiction out of which the summons was issued, that the defendant resides there. So the defendant has 10 days in which to file his notice of intention to defend. Now the days, whenever days is to be computed in terms of the rules, it is court days. Right. So court days, 10 court days that the defendant has then to file its notice of intention to defend. Now the days we call dies inducia, you might have seen that. It means days of grace. That is the days that the defendant has to do the following step. Now for the notice of intention to defend, he has 10 days. So court days are to be included in the computation of any time expressed in days prescribed by the uniform rules or fixed by an order of court. Non-court days are Saturdays, Sundays, and public holidays. So court days are any days but Saturdays, Sundays, and public holidays. If no time is specified, the required act must be performed within a reasonable time. If time is expressed in weeks or months, weekends and public holidays are to be included. You will see when we do provisional sentence summons that there's 2 months in which the defendant can do something. And in that case, you would include weekends and public holidays. I'll explain it to you when we get there. So if time is expressed in weeks, that something must be done in terms of 2 weeks or a month or whatever, you include all the days. If it is not expressed in weeks or months, then it is only court days that you count, right? If it's in terms of a statute, it must be computed in terms of Section 4 of the Interpretation of Statutes Act. And then you count every day, including public holidays and weekends. You only exclude those days if the last day falls on any of those days. Okay. What am I saying here? It makes common sense, because the last day is usually the day on which you have to perform whatever it is that needs to be performed, the last day on which you have to perform that. So if the last day on which you have to perform falls on a weekend or on a public holiday, and it is in terms of time is expressed in terms of a statute, we know that the courts are closed, businesses are closed, and you can't go and serve it on them. That is why you only exclude the last day in that instance. Only the last day. For all intents and purposes, you count every day. Right, but we are not dealing with that now, we're dealing with court days. So assume the defendant lives in the jurisdiction of the court. The defendant has 10 days. The sheriff came to serve the summons. The defendant has 10 days in which to file a notice of intention to defend. Comes to you, you know you have 10 days. How do you compute the 10 days? Right, it's the dies inducia. the days of grace. And I have an example to illustrate it here. You must have heard of FOLI, first day out, last day in. That is the acronym that we use to remember how we compute the days. First day out, last day in means the day on which the sheriff brings the summons. That is the first day. First day out means we do not count that day. Right? The last day in is the last day. You count that day, and that is the day on which you must do the actual thing that you were supposed to do in terms of the rule. Right? So say summons is served on Friday, the 19th of March, 2021. I've just got an illustration here. I just want to quickly run through it. You don't count the first day because it's first day out, right? That is when the sheriff brought the summons. You don't count the weekend. That Sunday was a public holiday, so we got the Monday in South Africa as a public holiday. You don't count public holidays. Right, so the first day that you count would be the 23rd of March, and then you count each and every day until you get to a weekend. You do not count weekends. And then you count, and then we had Good Friday and we had Easter Monday, so that is not counted. And you will see that the 10th day would have been the 7th of April, and on that day you have to file it. You don't count the days and file it the next day. You file it on the last day, first day out, last day in. That is how you compute in terms of the uniform rules. Okay. So you have 10 days in which to file a notice of intention to defend. You do it within the 10 days. Right. So in the example where a simple summons is issued by the plaintiff, the defendant has 10 days in which to file a notice of intention to defend. Right. First day out, last day in. Now, because a simple summons has been used, now remember I told you earlier on that a simple summons can only be used in those 5 instances: for a debt or liquidated demand, for transfer of immovables, cancellation of a contract, what is the other? Delivery of movables. Yeah, for those 5 stuff, you use a simple summons. And the simple summons is one document. It includes the cause of action. It's just a summary of it. It can be signed by an attorney alone. You don't have to have right of appearance to sign a simple summons. The defendant says he's going to defend. Now, the defendant who wants to defend on a simple summons, he is not yet in a position where he can defend because he doesn't know all the details of the allegations. All he has is a summary of what was wrong. Why are you claiming from me? It can be as cryptic as goods sold and delivered, or there can be more information, but it is not all the information. In that case, the plaintiff must file a declaration. Now, a declaration is exactly the same document as a particulars of claim. It is where the plaintiff must now point by point set out what is the cause of action, what happened, when it happened, and how it happened, so that the defendant can be in a position to respond to that, to answer that. Right, so 15 days after the defendant, in the case of a simple summons, have filed a notice of intention to defend, the plaintiff must file a declaration, and then 20 days after the declaration, the defendant files a plea, and then 15 days after the plea, the plaintiff files a replication. That's in the case where a simple summons is used. Remember, you have limited instances where you could use the simple summons. Right, if a combined summons has been used, now remember, combined summons, as a summons and a particulars of claim. Particulars of claim must be signed by an attorney who must certify that they have right of appearance in the High Court. If he doesn't have, he signs it, and then an advocate must also sign it. Right? 10 days in which to file a notice of intention to defend for the defendant, and then 20 days after the defendant filed his notice of intention to defend, he must file a plea. And then 15 days after that, the plaintiff files a replication. Right, so this is just exactly what I've told you what a declaration is. Remember, a declaration is filed by the plaintiff where you use the simple summons and the defendant gives a notice of intention to defend, to place the defendant in a position to know all the details of the case alleged against him. It is equivalent of what would have been the particulars of claim if a combined summons had been issued. It fully expounds the plaintiff claim, not only concisely, as is the case of the simple summons. Right. Together with the plea, the defendant can file a counterclaim if he has a counterclaim against the plaintiff. Now, the counterclaim or the claim in a reconvention is the same form as a declaration. It is filed together with the plea, and it is customary when you file a counterclaim to state a paragraph where you're not going to cite the plaintiff is and the defendant is, because remember, it is now part of this claim. You file the plea and you file the counterclaim together. It is customary then to state that the plaintiff in reconvention is the defendant in convention. So the plaintiff here in this counterclaim is the defendant in the main claim, and the defendant in the reconvention is the plaintiff in the convention, and that the parties are referred to as before. So in the counterclaim, even though the defendant is now the plaintiff, you still refer to him as the defendant, because remember, we are now in the same matter, same case number. He has a counterclaim against the plaintiff. Right, and then you can, in the counterclaim, refer to allegations that you've made in your plea. So allegations contained in the plea and in the declaration of particulars of claim, you can incorporate it by way of reference. You can say, I refer to paragraph so-and-so of my plea. Then you don't have to repeat each and everything. Just remember, you're filing it together. So it can be read together. Right, the replication filed by the plaintiff 15 days after the plea has been filed is where the plaintiff then reacts or answers allegations that he didn't deal with in his particulars of claim that was raised in the plea. A plaintiff may not increase the ambit of the claim by making allegations in the replication, which travels further than the allegations in the declaration and the combined summons. He may not increase the amount or state a new cause of action in a replication. A replication is not another opportunity for the plaintiff then to strengthen his or her case. He just deals with allegations that he didn't deal with previously, that is dealt with in the plea. Right. Now, I told you that when we did the differences between the two proceedings, in the action proceedings, after the replication, there are further pleadings that can be exchanged. So 10 days after the replication has been filed, the defendant can file a rejoinder. And then 10 days after that, the plaintiff can file a surrejoinder. And then 10 days after that, the defendant can file a rebutter. And then 10 days after that, the defendant can file a surrebutter. Sorry, the plaintiff can file a surrebutter. So these pleadings, further pleadings, are automatically barred from being filed if the 10 days after the replication has come and gone. It expired. These are, if certain issues you want to raise pertaining to the matter that has been raised in the replication, you could use these pleadings. I have only once seen a rejoinder. I haven't seen anything further than that. Maybe some of you have, or maybe you will still. Just know that there are further pleadings in actions that can be exchanged. Right. Rule 18, like I told you earlier on, Rule 18 is the most important rule with drafting. Read it, know it, consult it, use it as a checklist, because there you will get all the information that must be in your pleadings that you draft. You can use that as a checklist, right? Rule 18 says that the title of the action, the description of the parties and the case number, as well as the name of the relevant division, shall appear as the heading. We've done that. And then it says every pleading shall be divided into paragraphs or subparagraphs and shall be consecutively numbered. Now, please number the paragraphs. What people tend to do in exams, They do not number the paragraphs. They start writing and they just write. Now you will see the importance of numbering your paragraphs when it comes to when the defendant must plead. We must know what paragraph is he referring to. So you must number each and every paragraph. So divide it into paragraphs and subparagraphs if you need to have further subparagraphs that deals with a specific aspect, and number it consecutively, right? Now, Rule 18 says it must contain the full facts, a clear and concise statement of the material facts, which the facta, which we refer to as the facta probanda. Remember, we do not plead evidence. Evidence is the facta probantia. That is the evidence that is going to prove the facts. That is what you're going to do at the trial. You are going to bring the evidence that's going to prove the facts as alleged in your pleadings. So you only plead facts. Now, Rule 18.6 tells you how you should deal with a claim for breach of contract. Right. Now, Rule 18.6 says, if a claim is for breach of contract, you must state whether the contract that was entered into between the parties was written or was it an oral contract. And if it is the written contract, Rule 18 says, then you must attach a copy of the written contract to the particulars of claim. You must also state who represented each party, who represented the plaintiff, who represented the defendant. When was the contract entered into? Where was the contract entered into? What is the salient terms of the contract? Was there a breach? Was there any performance? So check that as your checklist. Similarly, claim for divorce, Rule 18.8 and 9 deals with that. Claim for damages for bodily injuries. Those of you in practice, claim for damages for bodily injuries, you will know that there is different heads of damages as we refer to it. You can claim for general damages, that is for pain and suffering. You can claim for loss of income, future loss of income, past loss of income. You can claim for medical expenses, past medical expenses, future medical expenses. So all of those damages must be separately stated. Rule 18.10 tells you that. You must also state the injuries that has been sustained, whether it is permanent, whether it is temporary. If it is temporary, how long is it expected to be? What was suffered? All of that, it tells you everything that must be in there. And then Rule 18, I think it's, can't see it's at 12, says when a person has died and you're claiming loss of support because that was the breadwinner, then you must, sorry, that's 18.11, then you must, what must be included. Rule 18.12 says that if you do not comply with Rule 18, then such a pleading shall be deemed to be an irregular step. Is there somebody that wants to ask something? Sorry, I didn't see your hand. Yes. There's a hand up. Is there a question? Nope. Okay, I shall continue. I know I'm going very fast. I'm just trying to cover some ground, but let me tone down a bit. Right. So irregular steps. Now, if you've done magistrates court practice, you will know that irregular step is when your opponent does something that is not in terms of the rule, that is not right. Then there is a procedure that you can follow. In terms of rule in the High Court, it is Rule 60. In the Match Court, in the Match Court, it is Rule 60. In the High Court, it is Rule 30. So you can have that pleading set aside if you follow that procedure. We'll do irregular steps later. I'm just mentioning it here. Now, I also want to, at this point in time, mention, for those of you that have read your Magistrates Court Practice Manual, you would have noticed by now that the rules in the Match Court and the rules in the High Court are word for word mostly the same. They've taken the High Court rules and they've incorporated it into the Match Court in 2008. They've done that. So, there used to be a lot of differences before. Now there are minor differences, which I'm sure will be shown to you by your lecturers, who's giving you magistrates court practice. When you study, you will see the numbers are different. Like, for example, irregular proceedings are dealt with in the uniform rules by Rule 30. In the magistrates court rules, it's Rule 60. But word for word, it is exactly the same. So if you read the one and you know how to do it, you will know how to do it in either court. Okay, just remember that. So if you study, look at both rules. If you say you do summary judgments are being dealt with in terms of Rule 32 in the uniform rules, Rule 14 in match court rules. Look at it both, it's exactly the same. And then see how you do it. The cases are obviously the same cases that applies. Okay, right, so drafting particulars of claim now, if the cause of action is based on a contract, you would first start. Now I said Rule 18 says you divide it up into paragraphs and you number the paragraphs. So your first paragraphs, you will start and you will identify the plaintiff. You will cite the plaintiff. Remember Rule 17, you cite the plaintiff, full name, sex, what is it? Occupation and address. Right. And I know I once had a long debate, I don't want to go in there now, about how people identify, because the rule says male or female. There's people that identify as non-binary and all of that. The rules has not been amended to include that yet, but I'm sure it won't be wrong if you say non-binary in the particulars of claim. Right, and if you say them in place of her, like is the preference of some people. So you would start by identifying the plaintiff, identifying the defendant, however many there are. So if there are 10 plaintiffs, you will say the first plaintiff is, that's one paragraph, and you will describe. The second plaintiff will have a new paragraph. You won't have all the plaintiffs in one paragraph. Have one fact per paragraph. Okay, so you will start with the plaintiffs and then the defendants. And then usually, from the party's description, you will see whether that person has legal standing, locus standi. Is it an adult male? Is it the executor of an estate appointed by letters of appointment from the master, and then the date and the number of the estate, and all of that details must be there. So you will be able to ascertain from the citation of the parties whether in fact the parties do have legal standing, right? Then you will also have to include a paragraph for jurisdiction. Now, in practice, people sometimes leave out the jurisdiction paragraph because it is apparent if you read the pleadings as a whole that the court has jurisdiction. It's not an issue. But for exam purposes, please have a paragraph to say this court has jurisdiction by virtue of the fact that the cause of action arose there, or whatever reason may be, because you get a mark for that. In practice, you can leave it out if it is apparent, but when you're drafting in exams, include as much information as you can, right? So you will have the jurisdiction, and then you start with the cause of action. And if it's contract, when and where was it entered into? Was it writing or attached? Who represented the parties? What was the material terms? And all of that. And you have it all in separate paragraphs, one fact per paragraph, concise and clear, because remember, the defendant must respond to those paragraphs. Right, and then the obligations and performance tendered by the plaintiff, and then obligations of the defendant. And if there was a breach, what it was, you describe it. If you describe the breach in one paragraph, and maybe you want sub-paragraphs to have finer details, do that. And whether you accept, whether you want to cancel the contract, what is the consequences of the breach, and what is the damages that were suffered, the quantity of the damages. And then that if you had to comply with any statutory requirements, whether you have, or if you've sent a letter of demand, that you sent a letter of demand and no reaction thereto. And then your praise, what you are asking for. And remember, in the High Court, one of the praise are always further and or alternative relief, because the High Court has inherent jurisdiction. and can give you alternative relief should you have made out a case but didn't ask for it. Right. Delete. Right. Again, the parties, the locus standi, the jurisdiction, and then the relevant facts. You basically telling a story. What happened, where it happened, when, one fact per paragraph. It's very easy to draft because in the exam and in practice, your client tells you the story. In the exam, they give you the words on the papers. You must just give it back in a certain format. So all the relevant facts are there. You just give it back in a certain format. Plead the relevant facts, when, where the delete complained of, and the manner in which it was committed. What was the breach? What was the duty of care that was supposed to be applied? What is the consequences? The sequelae, because of this, the causal link, remember delete, the causal link. Because of this, now I can't do X, Y, and Z anymore. I can't go to work. I can't play with my children. Whatever the consequences. And then you say what the damages is, and you have your different heads of damages in delete, if there are different heads of damages, and you quantify it. And then if you had to comply with statutory requirements, you say that, or if you sent a letter of demand, you say that, and your praise. So that's just two examples of how to draft, because the BBST exams are basically drafting. You're going to draft. So if we were in each other's presence, I would have now given you something to draft. I'm not going to give you, because how am I going to check it? We're just going to move on. Right. Are there any questions on that? Because I'm now moving to something else. Yes, there's a hand. Sorry, I didn't see it. Hello, there's a hand up. I don't know whose hand it is. It is ultra orthodox. What was his name again? Leonard. Leonard, your hand is up. You are still on mute. I'm just gonna go on because you're not responding. Right. Okay. Now coming back to when the defendant gives a notice of intention to defend, right? What happens if you issue summons, you're acting for the plaintiff, and you are the attorney for the plaintiff. You've now issued summons, you've done your particulars of claim, everything is fine. And then the 10 days, which the defendant has to file a notice of intention to defend, comes and goes. You compute the days, first day out, last day in, you don't count weekends and public holidays, and the 10 days is gone. What can you do? You can apply for default judgment, right? If the defendant does not enter a notice of intention to defend, then you can just apply immediately for default judgment. You don't have to even tell the defendant, because you didn't send me a notice of intention to defend, I'm now going to apply for default judgment. You don't have to do anything like that. You apply for default judgment. If the defendant gives a notice of intention to defend within the 10 days, and now the defendant, say for example, a combined summons has been used. So the defendant must now 20 days after the notice of intention to defend has been filed, file a plea. And he doesn't do that. So the plea is now late. The 20 days has come and gone. You realize the plea is outstanding. You can also apply for default judgment. But in this instance, because the defendant has already indicated to you that he is going to defend, you can't just apply for default judgment without letting him know. You must now first ask him, where's your plea? You said you're going to defend, now where's your plea? So you will send him a notice of bar. And in the notice of bar, you will give him an extra 5 days in which to file his plea. And if he doesn't file his plea within that 5 days, then he is barred from pleading, and then you can apply for default judgment. So that is how it works. No notice of intention to defend, you can just apply for default judgment. If there was an intention, you must let him know, look here, where's your plea? It is late, and he gets 5 extra days. Right. You can also, in a default judgment, apply to the registrar, and that is in the case where the claim is for a debt or a liquidated demand. Then you don't have to go to court for default judgment. You can apply to the registrar, and the registrar can also give default judgment, right? In terms of Rule 31, the registrar has certain powers. I will put it up now. If it is not for a debt or a liquidated demand and you have to prove damages, then the registrar can't adjudicate on that because the registrar can't determine damages. The court will have to do that. There has to be judicial oversight. The same for a liquid claim. Yes, is there a hand? Is there a question?
Yeah, I'm not sure if my hand is up, but I have to ask this question now. So you indicated, can you hear me?
I can hear you. Yes, I'm listening.
All right. You indicated that if the defendant doesn't file a notice of intention to defend, one can apply for summary judgment on that.
No, default judgment. Default.
Sorry.
Summary judgment. Yes.
Default judgment. Okay. If it was summary judgment, then I understood that the rules were actually changed. You have to wait for him to file a plea.
No, we're not doing. We didn't do summary judgment yet. We're still with default judgment.
Yeah. I apologize. I got a bit confused.
No, it's fine.
Sorry.
It's fine.
Thank you.
There's another hand up, Leonard. Your hand is still up. Do you want to ask a question? I think you're not here. So yes, Hassan, is that all? Mr. Hassan?
Yeah, that's all. Thank you so much. Thank you.
Okay. Fine. So yeah, so you can go to the registrar, and the registrar has certain powers, like I said, in terms of Rule 31 of the Uniform Rules. The registrar can't adjudicate if damages has to be proved because that has to be done in front of a judge. Likewise, the registrar can't declare immovable property to be executable or executable, however you say that word, because there must be judicial oversight when that is done, especially if it is the primary residence. Right. So in terms of Rule 31(5)(b), the registrar has the following powers. He may, in terms of Rule 31(5)(b), grant the judgment as requested, grant judgment for part of the claim only, or on amended terms, refuse the judgment wholly or in part, postpone the application for judgment on such terms as he may consider just, request and receive oral or written submissions, and require that the matter be set down for hearing in open court. Right, that is all the powers that the registrar have. Now, if the registrar has given judgment by default, remember it must be a liquidated claim. Any party who is dissatisfied with that judgment granted or a direction that the registrar has given may, within 20 days after he has acquired knowledge of that judgment or direction, set the matter down for reconsideration by the court. So you can take it to court and set it down in open court, right? It's not a rescission. This is now the registrar's decision. If somebody is not satisfied, is dissatisfied with that, he can set it down in open court. Right. The notice of bar. Remember, I said that if the defendant give a notice of bar, a notice of intention to defend, now 20 days after the notice of intention to defend, he must file a plea, and he doesn't. You send him a notice of bar first as the plaintiff, and the notice of bar looks like this. There's an example in your manual of a notice of bar. I can actually tell you exactly where it is so that I can assist you. The notice of bar you will find on page 245. Right. So please take 245 of your manual. Please take notice that the defendant is required to deliver his plea within 5 days after the day upon which the notice is delivered, failing which the defendant shall be in default and ipso facto barred from filing a plea signed by the attorneys. Now, what happens if once you, the rule says that if the defendant doesn't file his plea within 20 days, you can have that time extended by agreement between the parties. So the attorneys can agree. The defendant's attorney phones the plaintiff's attorney and says, look, I'm going to be late. They can come to an agreement that he's going to file it late. Or otherwise, if they can't come to an agreement, the court can decide. If the court doesn't, if the parties doesn't agree, then the court will obviously have to be brought into play. Now, to lift a notice of bar, say the 5 days has also come and gone, and the defendant is still in default of filing his plea. To lift that notice of bar by not being ipso facto barred from filing a plea and the plaintiff then getting a default judgment, you have to bring an application to lift the bar to court, and then you have to demonstrate to the court that you have a very good reason as to why your plea is not filed timeously. So you weren't willfully disregarding the rules of the court and give a very good reason. It can be that the defendant is out of the country and you can't take instructions, or there can be myriad of reasons why you're not filing timeously. And then the court may lift the bar and allow you and then order when you should file your plea. Obviously, if such applications are to be brought, the successful litigant is entitled to the costs of that application, and the unsuccessful litigant will not pay. But in a case like this, if you did not comply with the rules and you have to go to court so that the court can come to your assistance, the court will order cost against you. Okay, it just makes sense. Right. There's a hand, Hassan and Rosalind. You may ask.
Okay. In terms of this notice of bar, does it apply to divorce proceedings as well, where a person puts a notice to defend, and that's
But
if they don't?
Yes. Yes, it does, because a divorce proceeding is an action. It always has to be an action. So if the plea is late, you can put him under bar, and if he doesn't file it, then you can he's barred from pleading, and he'll have to lift the bar by bringing an application to court.
Okay, so in the case where he refused to sign the divorce proceeding, does his notice? Yeah, does his notice to defend have anything to do with it if there's kids involved?
Okay, I don't understand the question. What did he refuse to sign, ma'am?
The divorce papers. If he refuses to sign because he puts the notice to defend, can it go through without him signing, or does he have to sign?
Sign what? What notice?
The divorce itself, the papers.
Are you talking about a consent paper, an agreement?
A divorce document.
Okay. Are you talking about the sheriff bringing a document and delivering the summons to him?
Yeah, the summons. Yeah, the divorce was delivered by the sheriff to him, and he put a notice to defend.
Okay, so that is not the issue. Now, what is he refusing to sign?
The divorce itself.
He refused to sign an agreement. He refused to come to an agreement as to what's going to happen.
Yes, he's basically contesting.
So then he must file a plea. And if he doesn't file a plea and the 20 days has come and gone, then you have to place him on bar, and then it is an unopposed divorce then, if the bar is not lifted.
Okay. All right. Thanks.
Okay, thank you. Somebody else's hand was up, Mr. Nasir Hassan. Mr. Hassan?
Oh, no, my hand is supposed to be down, supposed to have been down long time.
Okay, fine. Thank you. Okay. Right. You can also get default judgment for the defendant, right? This is now in the case where simple summons has been used, And the defendant said, I'm going to defend. He filed a notice of intention to defend. And remember, if a simple summons has been used, the plaintiff must now file a declaration. And if the plaintiff does not file the declaration, the defendant can actually serve a notice of bar on the plaintiff. And if he still neglects after the 5 days in which he got extra, then the defendant can apply to court for absolution from the instance. Now, absolution from the instance means you're absolved from the instance because the plaintiff did not present or prove a prima facie case. Now, in this case, the defendant can apply for absolution from the instance because there's no prima facie case because the declaration was not forthcoming. Right. Another instance where you could apply for default judgment is if the defendant does not appear at the hearing. So you have the case set down. You went through all of those proceedings, pre-trials and whatever, discoveries, and now you have the court date and you're in court. And now the defendant is not there on the day. Then the plaintiff may apply for judgment by default against the defendant, provided that the claim is liquid. If the claim is not liquid, the plaintiff may still apply for judgment by default, provided that evidence concerning the damages is tendered. Now, we see that for those of you who are practicing in Gauteng especially, you will see a lot of this where the defendant is the road accident fund. And when they stopped instructing attorneys to appear on their behalf as defendant's attorneys. So when the matter is set down in court by the plaintiff sometimes comes to court and then the defendant is not there and they didn't participate. In many cases, the plaintiff then asks for default judgment, and if there are damages, obviously there are because it's personal injury, then they prove the damages and they get default judgment. So that is another aspect of default judgment. So it's either no notice of intention to defend or notice of intention to defend and no plea, or not appearing at all at the hearing. Right. Now, once you have judgment has been granted in your absence, because you did not receive the summons or you allege that you didn't receive the summons, then you can apply for rescission of judgment. These rules deals with decision of judgment by default granted in your absence. When you bring a rescission of judgment application, it does not, like an appeal, suspend the execution of the judgment. If you bring an application for rescission, the plaintiff who has a judgment can still execute that judgment. The only way to stop him is to bring an application in terms of Rule 45 capital A, where you are going to ask the court to stay the execution of the judgment pending the rescission application. It is not automatically. Like, for example, when you note an appeal against a judgment, the judgment is suspended up until that appeal has been dealt with. Now, with rescission, it's not the same. You have to bring a specific application also together with the rescission, or you can agree that the plaintiff can agree that he's not going to execute on the judgment. Right. So Rule 31, 6A and B deals with rescission of judgments. That is, if you didn't know that the summons was served, you only, when the sheriff came to your house and said, I'm coming to execute this judgment, and this is the first time you hear of that, you can go to court and apply for rescission of judgment. Rule 42 also deals with rescission of judgment. Rule 42 specifically deals with the instance where judgment has been granted, both parties was there, but there was a mistake common to the parties, or the court would not have granted the judgment if the court had known certain facts. Yeah, just remember those two rules. And you apply for rescission of judgment 20 days, within 20 days after it had come to your notice, or ought to have come to your notice. 20 days. Otherwise, you're late. And if you are late with any application, you must also bring an application for condonation. So you must also ask the court to condone you not complying with the rules in terms of the times. And then you must explain to the court your reason why you are late. And also, when you apply for condonation, you should always also demonstrate to the court that you have very good prospects of success. Because if you don't have prospects of success, then the court won't condone you being late with an application. The court will say, but why should I condone it? You're not going to succeed in any event. So in an application for condonation, you always also go to the prospects of success and you explain to the court why you have a good and strong case. Okay, I know I'm going very fast and I know Hontle, your hand is up. I may have questions.
Hi, how are you? Hope you're
I'm
good.
well.
I want to ask about the rescission.
Yeah.
Bring an application whereby they didn't know, didn't know about where the summons was served and that. So I needed clarity. I need clarity on this one. In a scenario whereby the summons was served on an address, like I moved, and then they were served on the previous address where I used to stay, and then the summons was served there. I was not notified when they were served there, and then the default judgment was granted in favor of the plaintiff if I'm the defendant. Can I bring an application for rescission on that matter?
Yes, 20 days after it comes to your notice. But then you must also prove in the application for rescission, you must also show that if you are allowed to defend the action, that you will be successful. So you must also address that aspect. And the reason for you not defending the action was because you didn't know about it and then set out the circumstances. Yes, you can apply for rescission, but then you must also demonstrate to the court that you will have you have a defense.
Oh, I
in any event.
Okay, no, I hear that. Thank you.
No problem. Are there any other questions? Right, let's move on. If the plaintiff does not appear at the hearing, now the same thing as with the absolution from the instance. If the defendant comes to court and the plaintiff is not there, the defendant may ask for absolution from the instance or may move for judgment in his favor, provided he has presented the necessary evidence. Now, what absolution from the instance is, for those of you who don't know, the defendant is absolved from the instance. That means the defendant does not have to put forward his defense. He's absolved from the instance because the plaintiff did not prove a prima facie case against him. So when the court absolves a defendant from the instance, the plaintiff may, at a later stage, institute proceedings again. It doesn't bring an end to that. It doesn't finally deal with that issue. The plaintiff still has a chance to come to court again, provided the claim have not prescribed. Okay. Right. What must be in counsel's brief in matters if matters were brought before the court? If the defendant is in default with his notice of intention to defend, a copy of the summons, a copy of the return of service to show that it has been served, a copy of the notice of set down, and statement or other documents to prove the quantum of the plaintiff's damage. Right, you'll see the copy of the notice of set down. Now, this copy of the notice of set down is not for the purposes of the plaintiff serving it on the defendant. This notice of set down is for the registrar. Because remember, the registrar, people who works in that room must know that they must take out the file and put it in the pile for that date when it is set down so that it can go to the judge and so that it can be on the court roll. That is the notice of set down. Right. If the defendant is in default with his plea, a copy of the summons, and if a simple summons have been issued, a declaration, copy of the notice of intention to defend, and a copy of the notice of bar, a copy of the notice of set down which was served on the defendant. Where the plaintiff is in default with his declaration, these are all stuff that must be in the brief if you're going to brief counsel or if another attorney is going to court. A copy of the simple summons, a copy of the notice of intention to defend, a copy of the notice of bar, and a copy of the notice of set down. Right. Let me just pause here for a moment. If a matter is set down on the roll for default judgment, right? And you are now in court and the matter is on the unopposed motion roll for default judgment. If the defendant rocks up at court and he says to the court, I want to defend, or he tells you, I want to defend this action. I didn't file my notice of intention to defend, but I'm here and I want to defend. You can't, the court won't ignore and say, no, you can't defend. Obviously, the court will make a cost order, or you must tender cost as the defendant for the wasted cost that was incurred because the plaintiff is now in court with this unopposed motion, but you will still be allowed to defend. Right. Because that happens a lot, especially with the banks, where they issue summons, no notice of intention to defend is filed, and on the day that it is set down in court, the defendants rock up and they say they want to defend, and the court will say they must be given an opportunity to defend. Okay, the court won't close the doors of the court to you. Yeah. Moving on. Somebody's on and microphone is on. Do you want to speak? Dolly? Dolly Engelbrecht?
Yes, was the previous page just your the previous slide page your 147, 149, 146, sorry.
I don't know if it's this one.
Yes, is that 146?
I have no idea.
Okay,
let me see.
That's fine. Thank you. I think I missed the slide. I'm not sure which one was it. Thank you.
Oh, yeah, this is just what must be in this is all in your, this is exactly as it is in your notes.
That's fine,
right.
Thank you.
Okay, now we come to summary judgment. Right, now summary judgment, the rules have changed in 2019. And we didn't pay much attention to it because we didn't practice it a lot because we had COVID and we didn't go to court and stuff happened. And now suddenly we're sitting with summary judgment. We have to deal with it now. In terms of the new rules, if the plaintiff's claim is based on a liquid document or for a liquidated amount in money or for delivery of specified movable property or for ejectment, only for those 4 instances, if the claim is based on that, the cause of action is based on that, then the plaintiff may apply for summary judgment within 15 days after receiving the plea. Right. So you apply for summary judgment 15 days after receiving the plea. The summary judgment consists of a notice of motion and an affidavit in which the plaintiff or the other person who can swear positively to the facts must verify the cause of action. He must say the cause of action as stated in the summary judgment, I verify that. He must verify the amount that is claimed. He must identify any point of law relied on. He must identify the facts on which the plaintiff's claim is based and explain briefly why the defense as pleaded does not raise any issue for trial. So the claim must be based on one of those 4 things: liquidated amount, liquid document, movable property transfer, and ejectment. There's a notice of intention to defend and a plea has been filed. 15 days after the plea has been filed, the plaintiff can say, no, I'm going to apply for summary judgment because your defense as pleaded does not raise any issue for trial. Right. You will have an example of a summary judgment application in your notes. It's like between your notes. Let me just. Show you where it is. Are people following their notes? In the notes, application for summary judgment on page 103. You will see where it says in the middle of the page, please take notice that the plaintiff intends to make application on. on page 103 of your manual. There is an application for summary judgment. Right. Now, summary judgment, if the claim is based on a liquid document, a copy of the document shall be annexed to that affidavit. Then the application will be set down not more than 15 days from the delivery of the application. Right. What do you do if you are appearing for the defendant and the defendant is now served with the summary judgment application? He filed his plea and here he receives the summary judgment application. Well, in terms of Rule 32, the defendant has two options. He can either provide security to the plaintiff to the satisfaction of the registrar to satisfy the judgment, including the costs which may be granted against him, or he can file an affidavit in which he discloses the grounds for his defense. He further then embroider on what the defense as he set it out in his plea. So the defendant has these two options. Either he can give security, and security is not necessarily money. Security can be any form of value, which will still be valuable at the time when the trial is held. For the amount that is claimed plus the costs, if the registrar is satisfied, he pays that in and then he will be allowed to participate in the main claim. Or he can file an affidavit, which is what most people do. If you file an affidavit in resisting the summary judgment application, 5 days before the day the application is to be heard, and the court can allow him to call witnesses if the court, if you apply and the court gives permission, right? In the affidavit, the defendant must set out the grounds of his defense fully. He must not just say, well, he says it's not a triable issue and I disagree with that. No, he must fully then expand on it and say why he has a bona fide valid defense. He can also raise a counterclaim and says, I have a counterclaim against the plaintiff. And the test that the court applies when adjudicating on summary judgment is there a reasonable possibility that the defense may succeed on trial? And if the question is answered with yes, then the court will say, no, I am not going to grant summary judgment to the plaintiff. You must fight your thing out in the main action. Right? In summary judgment application, the court does not allow replying affidavit. So it's only the application, the affidavit by the plaintiff, and then the affidavit by the defendant if he chooses that option. No replying affidavit is allowed. No evidence on behalf of the plaintiff other than what he set out in his affidavit. That is all that is allowed, and no cross-examination is allowed. The court may ask questions to elucidate matters, as the court usually can whenever witnesses are called. And the court's approach is, should the court give leave to the defendant to proceed with his defense, then the court will say, okay, summary judgment application is dismissed. You may now go on. And then the plaintiff must then file a replication, and they go on with the normal preparation and conduct of proceedings as they would have had summary judgment not been brought. Now, in terms of Rule 32, Sub-Rule 9, this was now added also in 2019. If the plaintiff knew that the defendant relied on a contention which would entitle that defendant to leave to defend, the court may order that the action be stayed until the plaintiff has paid the defendant's costs. So what the court does here is the court gives a punitive cost order against the plaintiff. The plaintiff, when he knows that this defense, as stated in this plea, is a defense, it is triable, but he still goes ahead and applies for summary judgment. If the court is of the opinion that he ought to have known, and the court will be of that opinion, if the defendant is a legal practitioner is going to argue, but because of X, Y, and Z, they ought to have known this is a defense, then the court can order that the plaintiff must pay the costs of the defendant and that he can't continue with the matter until that cost is paid. That is how the court will deal and show its displeasure to the plaintiff. The same, and the court can make it not normal cost, but cost between attorney and client. So it can be the higher level of cost, the cost that the defendant had to pay his client in resisting this summary judgment application. Also, the same, if the defendant raised unreasonable defense and resisted the summary judgment, he knows he doesn't have a defense, the court can also make a punitive cost order against the defendant. That is summary judgment. In the brief, there must be a copy of the summons, a copy of the return of service, a copy of the notice of intention to defend, a copy of the application for summary judgment. Sorry, and it must also be a copy of the plea and a copy of the opposing affidavit, if any. I left out, this is one of those instances where I didn't put in a copy of the plea, where I forgot. Just remember, I told you about that. Are there any questions? I went quickly. Yes, there are. Dolly? Dolly, do you have a question for me?
No, I do not have my hands up. Sorry about that. I don't
No,
have
it's
any.
fine. And Nasir, you have a question for me? Nasir, you are muted. Nasir, you are muted. Nasir? Right. I'm going to move on. Right. Another way to get a judgment, and these judgments that we're dealing with now, default judgment that we did, and summary judgment, and this confession to judgment, is a shortcut. Yes, there's somebody now. Is a shortcut way. Yes.
It's me. I couldn't unmute myself, but I have a question on summary judgment.
Sure, go ahead.
You did indicate that summary judgment is an application,
yes.
Right? So, is it decided purely on papers? Because if the defendant opposes it, what then happens? I mean, is it set down for oral evidence, or does the court decide on the papers?
It's argument on the papers, but if you need to lead oral evidence, you can apply for leave to lead oral evidence. But usually, and mostly, it is dealt with by way of argument based on the papers. Because remember, there's an affidavit by the plaintiff, and then there's an affidavit by the defendant, and you argue the matter based on what is contained, the evidence that is contained in those affidavits.
All right. So if there are disputes of fact on the papers, will the court actually then set it down for the main trial, or dismiss the application and say, no, take it to main trial? Or will he actually hear? Will he hear the case in court for a summary judgment?
For summary judgment, the court will only listen to argument, and if the court is of the opinion that the defense as set out by the defendant may succeed if he proves it at the trial, if there's a possibility that he may succeed, then the court will dismiss the summary judgment application, and then the parties will participate in the matter up until it is set down for the main trial. The court won't deal with the trial at that stage. The court will dismiss the summary judgment application if the court sides with the defendant and say, what you are saying here, because at that stage, the defendant doesn't have to prove his defense. He must just convince the court that should he prove this, what he's saying in the affidavit, should he prove this at the trial, there's a possibility that he may be successful in his defense. Then the court will not grant summary judgment.
Yeah, I understand. But can you just define what is meant by argument? I mean, does it necessarily mean oral argument, or is it just argument as set down on the papers?
Argument is argument by the legal practitioners.
Sorry to take you back on
Based
that.
on the evidence that is in the evidence, and obviously you're going to, when you do your argument, you do the facts and the law apply to that facts. That is how you argue your matter.
Yeah, okay, I got it. Thank you.
So it is decided on the papers, and the court must just be of the opinion that that defense may succeed at the trial.
Yeah, although from what I understand, there could still be oral evidence on a summary judgment application.
Yes, by leave of the court, you have to apply if you want to call a witness, but it's not a trial as such. It's not the trial. If the court decides in favor of the defendant, then the trial must still happen. If the court decides that the defendant is not going to be successful, then that will bring an end to the matter and the plaintiff will be successful and will get summary judgment.
Okay, understood. Thank you. Sorry for wasting your time on this one.
No, you're not wasting my time. You're not wasting my time. Yes, Bontle. Is it Bontle?
Yes, it does one time. You know, I'm sorry to take you back to rescissions, man. But I see one of the requirement for rescission is that a defendant or a party applying for rescission must get a consent from the plaintiff, right? And surely in this case it's when the judgment is granted in favor of the plaintiff. So what happens in a case whereby the defendant doesn't get a consent, or is by any chance is there a possibility that the plaintiff doesn't consent to that?
Bontley, you are talking about rescission in the magistrate's court. In the High Court, there's no consent. That's not an issue in the High Court. You're talking about rescission of a judgment in the match court where you have to get consent. We're doing High Court practice here. Consent is not required.
Because what I'm seeing is that on page 99 of our manual is that it's rescission in terms of section Rule 31, Rule 31 and Rule 31.6 and Rule 32. So it means the Rule 31.6 is for the magistrate court.
No, this is all High Court.
Okay, so I'm asking based on that rule. Rule 31.6. So Rule 31.6, one of the requirement for rescission is that.
Yeah, let me just check the rule because I just now told you that quite the opposite of what he stated here. Consent must be obtained from the plaintiff. Form 2B must be used.
Yes. So I wanted to know in a case whereby what happens if the plaintiff doesn't consent to that?
Yeah. Let me sorry, let me just look at Rule 31.6 and I'll come back tomorrow and I'll give you a full answer to that, because I was under the impression this is only in the magistrate's court and not in the High Court. The last time I looked at this rule, it was not. And let me just rectify, 462 is not Rule 32, it's actually Rule 31. It's not supposed to be Rule 32, that's an error.
Okay, no problem.
Okay.
It means tomorrow.
I look at Rule 31.6 and I'll come back tomorrow and I'll tell you about that.
Okay, thank you on that.
Okay. Dolly, your hand is still up. Is it from earlier on?
My hand is down. I don't know what's happening on my side.
Oh, okay. Oh, fine.
Thank you.
Right. Also in terms of Rule 31 is the confession to judgment. Right. Now, a confession to judgment must be signed personally. This is now when the defendant says, look, I owe this money and I want to confess to the judgment. The court can give judgment against me for the amount. Then he can do a confession. The rule says that the confession must be signed personally by the defendant. And his signature must be verified by his attorney. Now, if the defendant doesn't have an attorney, it cannot be verified by the plaintiff's attorney. Then the defendant in that case must depose to an affidavit wherein he then confirms that the signature on the confession is his. Then the plaintiff apply for judgment in writing through a registrar to a judge in chambers. And then it's not in open court, but the judge will then give the judgment in chambers. That is judgment, confession to judgment. It is another way to get a shortcut judgment. It's also dealt with in terms of Rule 31. Right. Are there any questions on that? Nothing? So we're moving on. I just want to see how far we are in our oh. Right. Defendant's plea, special plea. No, I see we're still far from where we need to be. Now, we talked about the two important pleadings being the particulars of claim and the defendant's plea, because out of those two pleadings, we can see what it is that the parties are fighting about. Right? I just want at this stage also to bring to your attention. We talk about pleadings, which includes particulars of claim, the plea, the replication, all of those are pleadings. And then we talk about a plea. So a plea is a pleading, but not all pleadings is a plea. It just sounds similar. The plea is where the defendant sets out his defense, but the plea is part of the pleadings, just like a particulars of claim, a declaration, counterclaim. Those are all pleadings, right? Now, before you plea on the merits, you can raise a special plea. Now, you get different kinds of special pleas, and I'm sure you have done special pleas already, but I'm just going to do a few different kinds of special pleas. Special plea of arbitration. This is now if you're going to plead something outside of the merits, outside of the actual facts of the case. So a special plea of arbitration is when the parties have in an agreement, in a contract, agreed previously that if a dispute should arise between them, that they are going to resolve the dispute by going to arbitration. And then the plaintiff issues summons and the defendant gets the summons and he says, but look, we said we're going to arbitration and you didn't do that. He can raise that as a special plea. And in the special plea will say, in terms of our agreement clause so-and-so, we agreed that we will first go to arbitration. You have not done that. Therefore, that is the special plea. Therefore, the claim should be dismissed, or it should rather wait until the arbitration has been completed before you can proceed with these proceedings. A lis pendens will also delay proceedings. That is, if there is proceedings in another court between the same parties based on the same cause of action that is pending, then you can raise that as a special plea and say the same cause of action, we already have a matter pending between us, so therefore this shouldn't be brought here. Premature summons is where the plaintiff issues a summons, but he did not comply with statutory compliance. For example, he didn't, in terms of the National Credit Act, send a Section 129 notice, or in terms of the illegal, of institution of proceedings against certain organs of the State Act, didn't send a notice to the organ of the state that is going to institute proceedings, and he has just issued summons. That summons is then premature. And then non-joinder is where a party that should have been joined, that has a direct and substantial interest in the outcome, is not joined as a party. Right. Then you get special pleas in abatement, prescription. This special pleas brings the proceedings to an end. Right. A prescription, we know an ordinary debt prescribes within 3 years. So if a debt has prescribed, you can raise that special plea. A res judicata, also a special plea where the court has already decided the same cause of action between the same parties, and the court has made a decision. And then if the court doesn't have jurisdiction, you can also raise that as a special plea that there's an absence of jurisdiction. Yeah. Are there any questions? I see that it is past. Nothing. Okay, so
just a very quick last one.
Who's this?
Regarding DS Inducier, just for clarification, if it is 10 days and you said first day out, last day in,
yes,
and we got a bit confused. I got a bit confused. Does that necessarily mean he has to file it on the last day, or can it be filed any time within the 10 days?
Anytime within the 10 days.
Okay,
Anytime,
thank you.
even on the second day. But you know what happens? Then the next set of days that you start counting, you count from the day that you filed. So if on day 2 you file your notice of intention to defend, then you start counting your 20 days in which to file your plea from the next day. So that is why people wait until the last day, but you don't have to wait until the last day. It's just that you get more time the longer. Do you understand what I'm saying?
Yeah, 100%.
So you start counting your 20 days then from that second day. Yeah.
Absolutely. Thank you.
Okay. Yeah. No, you have 10 days. That's the days of grace, but you can do it anytime within those 10 days. Okay, Dolly, your hand is still up.
It's not on my side. Sorry.
Okay, no, fine. So that's that. I'll see you tomorrow. I'll answer the question of 31.6 tomorrow. I'll do my research and I'll come with the answer tomorrow.
Thank you. Good night.
See you. See you.
Thank you. Bye. Thank you, Advocate.
Bye.
Nasir.